Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator and Lead Recording Secretary for the Indiana Assembly. Continuing with Gen Ed Wednesdays, Declaration of 76 United States Constitution, a Common Lawyer Comments, clause by Brent Allen Winters. And you can purchase this material as well as other common law material by Brent Allen Winters at commonlawyer.com. Anna reminds us in her article 4400, our court system, of supporting Brent Allen Winters and receiving and learning from his volumes of work over the decades relative to common law. All right, we'll go ahead and get things going here. We're going to go over the study guide questions from last week's reading to put those answers in, and then we're going to have the reading for this week, and then we'll read through the slides for the questions so you're prepared to work through those questions through this week. All right, so the pages that we went through here are 199 to 206, and this is the YouTube link for that reading that we did last week. All right, so though our Constitution never cites the right, courts say that it arises from Amendments 5 and 6 having always been the common law standard. Number 2, the presumption of innocence stresses government's burden to prove each element of the offense charged beyond any reasonable doubt, and that the accused, being innocent, need never prove his innocence at trial. Number 3, third, neither any juror nor the judge is to draw any inferences against the defendant from his having been charged with a crime, his being in court, his being represented by a lawyer, or his choosing to remain silent, to not testify. All right, in this segment, reasonable doubt of guilt. Number 4, in a criminal trial, a just verdict demands clear understanding of reasonable doubt of guilt, but such understanding eludes jurors. Number 5, 23% of instructed jury members believed that when the weight of circumstantial evidence was equally balanced between guilt and innocence, the defendant should be convicted. Number 6, from before America's birth, common law's requirement of guilt beyond a reasonable doubt for conviction has been the standard for criminal cases. In 1970, the Supreme Court accorded constitutional dignity to this standard. Number 7, jurors nevertheless fail to distinguish proof by a preponderance of the evidence from proof beyond a reasonable doubt. In short, the juror must test the government's, this is number 8. In short, the juror must test the government's accusation, never the defendant's innocence. Number 9, thus the test of the juror's verdict is never his certainty of the defendant's innocence, but doubt of the defendant's guilt. Number 10, if it is not guilty, must be the verdict. Number 11, for a juror's doubt to be reasonable, he must infer it from fact or facts, and it must appear reasonable. Number 12, thus one must always test conclusions of logic for reasonableness in light of available facts. Number 13, the common law therefore frowns upon defining reasonable doubt as a doubt for which reasons can be given. Number 14, the juror can be sure the accused is innocent by having a reasonable doubt of his guilt, but he can never be sure the accused is guilty because he assumes, number 14. The juror can be sure the accused the juror it can be assured the accused is innocent by having a reasonable doubt of his guilt, but he can never be sure the accused is guilty because he assumes his fairness. Yeah, that was a very difficult one to find how that was answered by Brent. So that's what I am figuring. It fills this sentence in. So if you see something different, leave a comment and let's talk about it, right? All right, number 15. To sum up, the jurors not guilty verdict never demands certainty of innocence, but only reasonable doubt of guilt. Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Number 2, in sum, Amendment 7 bars any court from reconsidering any fact the jury has decided unless the common law, that is, due process, demands it. Number 3. To remember, says Stryker, a common law trial, unlike civil law inquisitions, admiralty, canon, martial, and international law, is more of a fact than a lawsuit. A fact suit than a lawsuit. In fact, even if the judge directs the verdict, the jury can by right refuse his direction. Number 5, the jury has, that was another one that it didn't exactly list it in here. So I'm going by it for application and delivery power to acquit in disregard of the instructions on the law given by the trial judge. So if you see something different as to how that can be answered, please give what you've learned from that and what you feel that is and why. All right. Number 6. But the findings of the jury in single cases trump all 3 branches of government, the way of the common law from its earliest days. Number 7, relying upon the finality of the common law jury as the country's court of conscience, our Constitution establishes the jury as supreme in particular cases above the co-equal judicial, executive, and judicial branches. Number 8, because the Constitution is the source spring of every federal court's authority, no court is greater than the Constitution. Number 9, in spite of any misapplied provision, the principles of the Constitution, being first principles of common law government, never change. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted. Number 2, half of those jailed in America are there on nonviolent and victimless charges, often for acts of merely offensive to popular sensibilities, such as a petty drug possession or taking a tax deduction the government dislikes. Number 3, in short, any punishment beyond the degree of wrong done is cruel and unusual. This includes bar against torture. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained. Number 2, remember the chief purpose of our Constitution is to limit government so that we will be free, right? In sum, Amendment 9 bars government from whittling down any right to balance it against another or ignoring any unlisted right. Number 4, our Constitution delegates a few listed powers to the general government, but leaves innumerable powers in the states and the people. Number 5, our Constitution is a compact draft of common law limits for government and common law protections for individual rights. Government's reach ends where your rights begin. All right, so now we're going to go ahead and go through this reading. All right, it's pages 206 to 212, and here is the link for YouTube. And we'll go ahead and get this started.
Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator and Lead Recording Secretary for the Indiana Assembly. We are continuing with Brent Allen Winters' Declaration of 76, United States Constitution, a Common Lawyer Comments. And as you can see from the link above, you can go to his website, commonlawyer.com. All right, we'll go ahead and get things rolling here. So you can see that. All right. Oh, gotta remove that. Okay, here we go. Amendment 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, or preserved to the states respectively, or to the people. Comment. Amendment 10 says the Supreme Court states a truism, a fact so self-evident that to question it is silly. The states and the people keep all the powers that the Constitution have not delegated or given to the general government. In fact, our Constitution is the only channel through which the states can empower the general government to do anything. Bottom line, Amendment 10 bars the feds from using any power or Constitution Amendment 10 bars the feds from using any power our Constitution never grants them, while ensuring that the people of each of the states stay free to use those powers. These are the just powers, U.S. Declaration of 76, Section 2, which spring only from God, see Romans 13, 1-2, and disperse to the individual, granting the right to act respecting a given matter. Such a right never floats in the air, belonging to no one, and always includes a personal duty to use it according to the divine pleasure. Thus, Amendment 10 keeps at the local, accountable level those powers our Constitution never gives to the general government or prohibits to the states. However, most federal activity nowadays being outside our Constitution's list of powers usurps powers the states which the people of each state have never given the general government, thereby violating Amendment 10. Each state has sovereign power. Read any state constitution. Amendment 10 keeps that power at the state level, where the people are best able to reach those abusing power and throttle them. See this handbook, U.S. Declaration of 76, Section 8, and comment. Nowhere do federal dependents do more hurt to our Constitution than in defining, prosecuting, and punishing crimes beyond those four our Constitution enumerates. The Constitution of the United States, having delegated to Congress a power to punish treason, counterfeiting the securities and current coin of the United States, piracies, and felonies committed on the high seas, and offenses against the law of nations, and no other crimes, any act of Congress assuming to create, define, or punish crimes other than those enumerated in the Constitution is altogether void and of no force. The power to create, define, and punish such other crimes is reserved and of right belongs solely and exclusively to the respective states, each within its own territory. James Madison and Thomas Jefferson. According to these clear statements, all Congress-invented crimes are unconstitutional. In fact, because the general government has now created and punishes almost 6,000 acts beyond these four enumerated crimes, no loyal American is safe from false political prosecution. Here, the undisputed fact is that the Constitution was made by the people, but is embodied into the several states who were parties to it, and therefore made by the states in their highest authoritative capacity. Letter from James Madison to Daniel Webster, March 15, 1833. This assent and ratification is to be given by the people, not as individuals composing one entire nation, but as composing the distinct and independent states to which they respectively belong. Federalist number 39. Give me leave to say something of the nature of the government. Who are the parties to it? The people, not the people as composed one great body, but the people as composing 13 sovereignties. Were it, as the gentleman asserts, a consolidated government, the assent of a majority of the people would be sufficient for its establishment, and as a majority have adopted it already, the remaining states would be bound by the act of the majority, even if they unanimously reprobated it. Speech to the Convention of Virginia of 6 June 1788. The general government, as early as the days of Madison and Jefferson, began kicking over our Constitution's traces. Nowadays, government has become a powerful runaway team that congressmen and presidents whip without even holding the reins. See generally Prince versus U.S. 521, U.S. 898, 1997, setting clear limits on the general government's authority over any state of the Union. I consider the foundation of the Constitution is laid on this ground, that all powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. To take a single step beyond the boundaries thus specially drawn around the powers of Congress is to take possession of the boundless field of power, no longer susceptible of any definition. Thomas Jefferson, Opinion on the Constitutionality of a National Bank, 1791. Amendment 11, offered 1794, ratified 1798. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. Comment. Amendment 11 clarifies Article 3, Section 2 of the Constitution, which gives diversity jurisdiction to the federal courts to hear cases between a state and citizens of another state. Our courts have interpreted Amendment 11 to stop anyone from suing a state. See Hans v. Louisiana, 134 U.S. 1, 1890. But to ensure that state officers would not escape federal law, Congress has passed legislation allowing actions against them. Amendment 11 was the first amendment adopted after the Bill of Rights ratification of 8 January 1798, and after the Supreme Courts having ruled that federal courts had the authority to hear cases in law and equity that a private citizen is brought against a state, and that no state enjoys sovereign immunity from another state citizen's actions in federal court. Chisholm v. Georgia, T.U.S. 419, 1793. Thus, did Amendment 11 clarify Article 3, Section 2 of the Constitution, which gives jurisdiction to the judiciary to hear cases between a state and citizens of another state. Amendment 11 grants immunity to states from suit for money damages or equitable relief without their consent. The Supreme Court held that when a state invokes a federal court's removal jurisdiction, it waives Amendment 11 in that removed case. Lapidus v. Board of Regents, 535 U.S. 613, 2002. Amendment 12, offered 1803, ratified 1804. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as president and vice president, and they shall make distinct lists of all persons voted for as president and of all persons voted for as vice president. And of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed, and if no person having such majority, then from the persons having the highest numbers, not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately, by ballot, the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as the president, as in the case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. Comment. Amendment 12 supersedes Article 2, Section 1, Clause 3, and was adopted to prevent the situation that occurred after the election of 1800. The Electoral College gave Jefferson and Burr tie votes, thus throwing the selection of president into the House of Representatives, even though the electors had intended Jefferson to be president and Burr to be vice president. Amendment 12, unlike Article 2, Section 1, Clause 3, requires each elector to make a separate designation for president and vice president. As a consequence of the disputed election of 1870, Congress enacted a statute providing that if the governor has not certified his state's vote under seal, it shall not be counted unless both houses of Congress concur. Amendment 13, offered 1865, ratified 1865. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. Comment. Though some believed it well intended, even necessary, Amendment 13 did little. Oppression of former slaves and slavery, in fact, continued for decades after. The war between the states destroyed the South's well-being, prolonging oppression that otherwise was moving sure-footed to an end. For instance, Virginia had long before the war set a date certain to end slavery. Going further back, long before Parliament ended slavery in Britain's colonies, Lord Mansfield found in the Somerset case no authority for slavery in all of England's common law history. Later, the Illinois Supreme Court in the Bryant case on facts matching Somerset, both were habeas corpus slave cases arguing freedom by virtue of free soil, found the same. See Brent Allen Winter's Excellence of the Common Law, subsections 3.7.12.1, discussing the English Somerset slave case and its bearing on American common law. Of great note, the words of this Amendment 13 does not forbid voluntary servitude. Remember, Parliament, at the behest of England's central bank trading monopolies, foremost the East India Company, had justified slavery and slavers in Britain's colonies, saying even though common law forbids slavery in England, common law has no force in the American colonies, therefore slavery is permitted there. Englishmen said England's soil freed the slave whose foot touched it, but justified slavery in our colonies, saying colonial soil was not as common law England's free soil. Thus, slavers trafficked slaves out of Africa and about England's colonies to the profit of England's banking and trading monopolies. Though the American colonies hated the English monopolies, through slavery they had become entangled with them. Finally, the words any place subject to their jurisdiction acknowledge that the jurisdiction of the general government applies not within any state. If it did, these words would have outlawed slavery in all the states, but they did not. To sum up, though appearing right in principle, Amendment 13, by using our Constitution contrary to its design to limit government, failed to end slavery and thwarts freedom to all. In fact, after the dust settled and the passions of the war subsided, Amendment 13, as also 14, lay dormant, unused for about 70 years. All right, that is the end of this week's.
All right. So we'll go forward here with the study guide questions, so you can go through this week and the reading and see if you're able to answer these questions. All right, let's move forward here. Okay, so Amendment 10. Number 1, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the blank respectively or to the blank. Number 2, it thus bars the blank government from using any power our Constitution never grants them, while ensuring that the people of each of the states stay free to use blank. Number 3, such a right never floats in the air, belonging to no one, and always includes a personal blank to use it according to the blank pleasure. Number 4, but most federal activity nowadays being blank our Constitution's list of powers. Blank powers the states, which the people of each state have never given the general government, thereby violating Amendment 10. Number 5, nowhere do federal dependents do more hurt to our Constitution than in defining, prosecuting, and blank crimes Beyond those four, our Constitution blank. Number 6, according to these clear statements of Madison and Jefferson, all Congress blank crimes are blank. Number 7, the general government, as early as the days of blank and blank, began kicking over our Constitution's traces. Number 8, to take a single step beyond the blank, thus especially drawn around the powers of Congress, is to take possession of a blank field of power, no longer susceptible of any definition. Thomas Jefferson. Amendment 11. Number 1, the judicial power of the United States shall blank be construed to extend to any suit in law or equity, commenced or blank against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. Amendment 12. The blank shall meet in their respective states and vote by blank for president and vice president. Amendment 13, 1. Neither slavery nor involuntary blank, except as a punishment for crime whereof the party shall have been duly convicted, shall blank within the United States or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. Number 2. Though some believe it well blank even necessary, Amendment 13 did little. Oppression of blank slaves and slavery, in fact, continued for decades after. Number 3, remember blank at the behest of England's central bank trading monopolies, foremost the East India Company, had blank slavery and slavers in Britain's colonies. 4, thus slavers blank slaves out of Africa and about England's colonies to the blank of England's banking and trading monopolies. All right, that's the end of those questions for the reading. So remind you that Mondays at 6 p.m. Central, the first and third Mondays, the General Assembly and Militia Assembly meet. Second and fourth Mondays, the Jural Assembly and Militia Assembly meet. We do broadcast on YouTube, Rumble, and Odyssey. Locals is more of an uploading as we are gaining enough supporters. We may be able to start doing live calls through there once we move away from Zoom the middle of January. So we'll see. But we are testing with the other calls as we're moving forward to get, because we're moving onward to free conference call, and that is here. You can go to freeconferencecall.com/wall/at home Indiana, and this will take you to the Assembly's wall here. All of the schedule has been put in up through the first quarter of 2024. You can click view all to get all of them in there. Here are links for links to go to, as well as downloads for important tools for you. If you'll notice here on the second page, Law of Peace. That's what we need to be working with. This is going to be huge to help us in this process. Times when there are calls that if you were not invited to the call or you just did not want to attend the call, you do have the ability to at least be able to listen to the radio as it's going in play. All right. Again, that's freeconferencecall.com/wall/at-home Indiana, so that you can be able to start sharing with us on free conference call. Don't forget to go to pktfnews.org to start following them and supporting them as well. All right. I thank you all, and I will see you on the very next call. I wish you peace and love. Thank you.